We have plenty of hypocrisy and plenty of nuanced issues to get to, so stick around. Bryan Kohberger's alibi had nothing to do with stargazing, despite my beautiful thumbnail. Actually, come to think of it, who knows if the thumbnail is beautiful or not, because I haven't made it yet. Dun dun dun! Cue suspenseful music. I'm pretty sure everyone has already read The Alibi, okay? So I'm not even gonna waste your time. And if you didn't, you already listened to someone reading it to you. So here we are, you and I. Us, them. And the very first thing that I think is the most interesting, and I'll lead this video off with, expert witness, which defense filed in their alibi who they plan to call at trial. Cy Ray is a former law enforcement veteran turned entrepreneur, and he's best known for founding ZedX Corporation, a company that's at the forefront of cellular geolocation technology used by police. He's credited with 20 years of experience, and that accreditation ranges from SWAT ops to leading homicide investigations. And Cy has transitioned his on-the-ground expertise to innovating it in the field of radio frequency, RF mapping and analysis. His work has been featured on 48 Hours and Dateline, but also includes critical RF technologies like drone detection systems for the NFL. When he's not revolutionizing law enforcement's tech or mapping that tech for them, he's advising on undercover operations. Cy claims to cherish quiet moments with his family in his Arizona ranch, and he's currently penning a book. Now, let's get off into the hypocrisy on the surrounding narrative of the case. Let's start out with what guilters have been uber excited about, and that's the fact that a judge critiqued Cy Ray's maps and stated that he held himself out to be an engineer. All right, let's make one thing clear. The term engineer, it's not just a degree, it's an action. You don't need an engineering degree to become an engineer. It's plain and simple. Job titles are more about your ability to perform and your depth of knowledge, not just degrees or college credentials. In this scenario, I believe there's a biased influence held over the court, and it's not one unfamiliar to the government in general. And what I mean by that is government is finally starting to realize that some of their credential bias is actually harming the government's ability to find talented employees and contractors. And it's something that's only been kind of newly recognized. And the judge stating something like this, to me, cast undue skepticism on an expert's qualifications and undermines their credibility without a fair consideration of their actual expertise or experience. People often cite Bill Gates as an example for this, okay? Because if Bill Gates were to apply for many government jobs in the cyber world, he would not qualify because none of his actual abilities were from formal education, and he in fact dropped out of Harvard before he ever earned any degree. And what did he do? Well, he started Microsoft. So this innovation and this entrepreneurial spirit can be kind of significant when you weigh it against like traditional educational paths. And this is becoming nothing but more and more true as many people can't afford college, and that has nothing to do with how talented or how capable they are. And of course, some people are lucky enough to get on the job training or, have experience through sometimes, as in my case, exactly, experience they didn't even necessarily ask for or seek to begin with. And what I mean by that is the fact that I've been in courtrooms since I was a minor, and I was able to start, getting that experience before I was even truly old enough, and sort of accidentally, I guess you could say, right? But moral of the story is that the government's starting to recognize that, but obviously this judge didn't, okay? And that's just some of the bias that we see in the government, in the legal system, and of course, often, unfortunately, in legal proceedings. Now, let's get to the next hypocritical part. It's kind of, I don't want to say funny, because, I don't want to be a whole ass, but whatever. I'll be the asshole. Okay, so the fact that they're all excited about this is kind of ironic because quote unquote pro-burgers the entire case have been stating how unreliable cell phone location analysis is. And it's not just pro-burgers, it's the scientific community, it's critics of the analysis that the FBI CAS team has been doing for quite some time. It's based not only on its theoretical validity, but also on the fact that it has no reliable fail rate. And here's the thing. there's a Gazette article, and in the entire article, they're actually criticizing the reliability of cell phone location data analysis. Now, this is a complex issue, but it's the nature of how cell phones connect to networks and the strength of that connection in order to determine someone's location. Now, the accuracy of location data is affected by numerous factors, including the density of cell towers, the topography, the surrounding area, and even the weather. Is there rivers nearby, etc., etc. One phone sitting next to the other phone can be completely connected to two different towers. Now, this inherent variability means that while cell phone location data can provide some insight, it's not infallible and sometimes it's not precise at all. And there's no universally accepted fail rate because the accuracy can vary wildly depending on all those circumstances, right? So the scientific and forensic community continue to debate this reliability. Now, the use of ZX is for a visual presentation. So police and prosecution teams use this presentation in courts. And the criticism in the Gazette article is aimed at ZX, or at least that's how it's worded. But truly what it's discussing is the accuracy of the underlying data that created this map. And the Gazette is sort of miscategorizing that and mostly blaming it on the technology that makes the maps, which is what Ray's business does. That's the expert witness being used in the Bryan Kohberger case. So disregard the whole Gazette article don't disregard it. Let me reword that, okay? We're not going to disregard it because it's absolutely true, but it's just sort of miscategorized as Ray's fault or something to do with his technology, and it's really criticizing the underlying data, which we've been doing the entire time, all right? So let's get to the hypocrisy of that. No, I don't really believe that cell phone data is reliable. I know that it's not. I know communications experts. In fact, I was married to one. So the idea that it could be that precise is a fallacy. And I don't believe it should be used in courtrooms. And I have hope and a spirit that hopefully, this is going to be trashed with a bunch of other junk science like hair forensics and other things that we've thrown out of American courtrooms before. And we won't be the first to have done it because Denmark, actually recently, if I'm not mistaken, like in 2019, disregarded this from their courts. It is now junk science in Denmark because there have been so many cases where it has been proven to be a fallacy and the police are not able at this time to use it any longer and bring it to court as evidence against a defendant for a crime. So plain and simple, this is not a Ray problem. This is a cell phone analysis problem when it comes to location from cell phone pings. And as far as, the ironic hypocrisy goes, this goes both ways. It goes with guilters from the case stating, what a crap expert. But then it's like, wait a minute, this crap expert that they're, calling him, what was brought to light in this court was that his fancy maps were going to make an underlying data that is not precise and has no available fail rate to look flashy and convince a jury. Now, and convince a jury of something that isn't there. And that's very important when it comes to expert witnesses, right? Because expert witnesses are legit our interpreters. They are who interprets data that is very complicated for the layman to translate. And court preventing Ray's maps from coming into the case that they are citing was in protection of a defendant from having an unreliable method of analysis used against them in court. That is the same method that the CAS team and the FBI investigators use to claim that they are interpreting data about where a defendant was at a particular time due to the signal strength and pings of their cell phones connecting to a tower. So as Ray used to be, he's grouped into that same category with police utilizing expert testimony, such as cell phone location data, quote unquote, to be utilized against a defendant in a criminal trial. So in this case that the judge was Xing his testimony out, it was in defense of defendant. And now everyone is, kind of backwards on that a little bit, right? Because now they're like, oh, crap, expert. Like, okay, well, there's probably a whole lot of people we need to let out of jail then. Well, we already knew that though, right? Moving on. So the other side of this hypocrisy is that, there's a lot of people who are like, yo, cell phone data ain't shit. And, now they're like, oh, we're going to prove it with cell phone data. Okay, well, I'm not going to be a hypocrite on this. I won't be convinced by the mapping of the cast experts and probably not Ray's mapping either. Although, I'm going to admit my bias here, right? I'm going to be, more willing to be like, maybe this is more correct, especially if he's saying like, yo, he's in the opposite direction, because I don't trust the investigators on this particular case, as far as honesty goes. I don't guess I trust a lot of investigators, but especially not these ones, okay? We have the hypocrisy going everywhere, all sides of the case. We have the Gazette miscategorizing this as a Ray problem, and it's really a cell phone analysis problem, and et cetera, et cetera, et cetera. Let's talk about another problem, and I've never spoken negatively about any of the victims' families, and I never will. In fact, I've taken up for them and taken up for Kara in particular, and many of the parents who have drug charges, and many of the allegations that have been thrown about pertaining to that, right? But here we have the family who put out a public statement. And I'm going to go ahead and guess that you guys have already heard or read this, but I'll try to read it really quick. Just skip through a couple of minutes if you've already heard it. But it says, quote, "We have been waiting on this information for months and it's finally arrived. It's so hard not knowing anything about the case. And then you find that you have to cling to dates, motions, and hearings in order to figure out anything. A big part of this has been waiting on the alibi information. Now that it is here, we feel more confident in the prosecution of the defendant. The defense's claim is that the defendant was driving late at night, hiking, running, stargazing. We're not sure why it's taken over a year for this to come out, as those don't seem to be complicated activities. We believe that if this alibi had any weight, it would have been submitted months ago. It also is in direct conflict with the probable cause affidavit that states that the defendant's phone was turned off between 2:47 and 4:48. So if the defendant was driving around and there is cell phone information that he was in a different place, it would be either before or after the times of the murders, hence not really an alibi. We continue to look forward to justice in this case and can now put this part of the process behind us. Thank you for all your support for our family." So here we have somewhat of a contradictory statement because, so many times they have doubted the prosecution, the investigation, et cetera, and I believe that that should continue. Here is one thing that I want everyone to remember about this alibi and the time pertaining to it being filed. This almost exact same alibi, lacking a couple of details, including the expert that will be a witness, including a location of one of the cameras that allegedly caught the car that police claim is connected to the murders, as well as a slight amount of added information about hiking and stargazing, which everyone has taken out of context and claimed that his alibi is that he was looking at the stars. And it absolutely is not. Reading comprehension is key, and if you go back through that alibi, you will note that that is just corroborating evidence, corroboration for the fact that he hikes and stargazes, and that, he might have pictures and or metadata that will back that up. Don't forget that we did have a warrant that went out to a company that happens to be one of the athletic smartwatches. And I'm very interested to see if that pertains to it at all. But here's the thing, and another bout of hypocrisy is that, okay, the guilters, as I'll call them, they are completely fine with the prosecution in this case, who claim to have been ready forever ago, who claims that they had all these cast experts and all of this data, who has still not turned over the full cast information. We can already tell, actually, from this alibi motion that a part of the motion to compel, which is going to be the next hearing that we see in the Kohberger case, is going to pertain to them actually getting that data from that cell phone analysis. And we've already got a hint of this in the past. There was actually a hearing where Anne brings up the fact that all they were actually given was a draft of this information, and that the defense attorneys for Kohberger still do not have the final draft report from investigators, okay? Now, this is something that they've been telling Triple J, Judge John Judge, that was an issue for them way back damn near a year ago. So that is only one of the problems from the Goncalves family's interpretation of this new filing, because like I said, the filing doesn't pertain to stargazing being used as an actual alibi, but a part of corroborating evidence that they plan to possibly introduce, such as past times that he stargazed, taking pictures of the moon stars, hiked, etc., etc. And we actually know that he was a hiker due to one of the prosecutors, I believe it was, who had stated in Lehigh County that he had actually looked for police reports pertaining to Kohberger, and that his bike was actually, or I'm sorry, his car was locked behind a bike trail gate, and that he had to actually call 911 and, request that they come and let him out, and that he even contacted them after that happened, apologizing and, stating thanks or whatever, sorry to be a bother. So we actually do know that this is obviously an activity that he partakes in. Not to mention in the search warrant, some of the things that they got out of his car, such as like some of the bags, could be camping bags, hiking boots, and, some other things. So there we already have some corroborating instances that are not necessarily related, but, they're not unrelated when it comes to like, okay, is this BS or not? Okay. So number one that I want to correct on their interpretation of this filing is that the stargazing does not pertain to it. We already mentioned that. Stop repeating yourself, Neeks. Okay, moving on. Number two is that the probable cause affidavit did not state that his phone was turned off. It stated that 3 possible things could be true: airplane mode, turned off, or not receiving signal. So we end number 2 with the firm statement that the defense's narrative does not inherently contrast with the information provided in the probable cause affidavit. But we do also recognize, that affidavit has some fallacies in there, as was noted by defense attorney Masseth in the last hearing that we heard for Kohberger, where she said, although if you guys want to say, that you guys put that stalking hint in there and it was irrelevant, she would agree, because she's like, yeah, I agree. There's a lot of stuff that's just plain out wrong in the probable cause affidavit. But to quote the probable cause affidavit verbatim, it is, quote, at approximately 2:47 a.m., the 8458 phone stops reporting to the network, which is consistent with either the phone being in an area without cellular coverage, the connection to the network is disabled, such as putting the phone in airplane mode, or that the phone is turned off. The 8458 phone does not report to the network again until approximately 4:48 a.m. All right, and third thing that I want to clarify about that is that it did not take defense attorneys a year to turn over this information. And in fact, they have already filed something very, very similar. And if you don't recall, about damn near a year ago, there was like memes of Kohberger driving his car at night and whatever. Oh, I'm just out driving about, dirty dirt. Where they were implying how stupid it was and whatever. We've been dealing with this shit for almost a year. It's insane to me that that just kind of goes in one ear and out the other. No comprehension for it later. And please note, I do not mean this in any direct correlation to the victims' families. Who knows how they're interpreting things? And God, if they interpret them wrong, Lord, we understand why. You know what I mean? So, like, I'm not talking about them anymore. This is a completely separate subject from them interpreting it that way. But what I mean is, like, I've seen this in the public a lot. Like, wow, it took them a year to say that. Like, no, buddy, bro. Like, skirt, go back. Let's go back to the extent that, there's been several motions pertaining to this, where there's been several filings pertaining to this alibi, and there's been several times that the prosecution has tried to prevent defense from even being able to introduce this at trial. It's been mentioned in motions and hearings for almost a year. And it started back in June of last year. And it actually ends at one point, until we heard about it again, with Anne actually asking the judge to let them have a private hearing with him without the prosecution present, if that was what it took, because not only did they accuse prosecutors of attempting to peek further into the defense's actual strategy and case, which is not something typically a judge should allow within reason, other than like discovery and a basic outline of the argument, so that you don't have an 11th hour defense problem or a prosecutorial problem, basically. So they've been talking about this for a long time, and it actually ends with Anne stating basically that she wished that the court would please exempt Mr. Kohberger from further inquiry because he requests such an exception at this time. And continued inquiry at this juncture delves into his case investigation as well as protected work product. So like I said, protecting one side from peeking too far into the other side's strategy. And in support of an exemption, Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court. But most importantly, and I hate that it's come at the end of the video, it's most important to realize the fact that the reason Anne is asking for these extensions, the reason Anne has stated, look, they are just trying to peek further into my case, is because she had already stated that it would be through cross-examination of witnesses that the prosecution would offer at trial. Therefore, she shouldn't need to bring these witnesses on a piece of paper because they're not her witnesses. It's during cross-examination of the witnesses that the prosecution has already put on the stand or will already be putting on the stand. Technically, there's a whole different deadline for when they have to fully disclose all expert witnesses that will be in the case, and you'll always see that in trial schedules. There will be a date specifically to disclose every expert witness, et cetera, et cetera. So, that's an Idaho thing anyway. It's a completely odd Idaho thing to me that defense needs to bring an alibi, as quickly or on such dedicated time restraints. That's kind of odd in my experience, but, full disclosure, this is my first time studying Idaho law, and I've learned a lot about it so far, and most of it I want to say ain't great, but that's besides the point again. Focus. Okay. After that, prosecution files a motion to compel, and they state that what Anne Taylor has stated in her original notification of an alibi was not actually a full alibi, and that she didn't disclose all of the information that was necessary pertaining to the Idaho criminal rules. Well, in this motion to compel, she responds and she writes back with each point and answers each point that prosecution pointed out that she had not fulfilled. And damn near on every point, a large part of the problem is that she did not have a final cast report, which she needed to further analyze in order to fully prepare that alibi defense, which, if you think about the fact that they don't have this final draft, a part of Anne's logistical problem could be that she does not want to hand them a date or a specific location that he was at before receiving the other end of that paperwork, because if we're looking at possible fabrication or possible framing, then we're looking at her logistically not wanting to give them too much or peek too far into her actual strategy, because they could easily insert that data into their final report so that it's not missing, and or, as she's pointed out in her latest filing, they're not having their non-disclosure of exculpatory evidence ass hanging out, right? They're covering that end of the base by inserting certain data that she may show through some other means exist, but was not turned over to her, if that makes sense. So basically, she doesn't want to hand him exactly what she's going to use because somehow he could throw that into the final report, because she's only received a draft so far. And the motion to compel is actually going to have something to do with that. As she mentioned in there, she still needs that to be done. And, it's coming up on close to a year ago now. She asked John Judge to please refrain from allowing the prosecution to continue to badger them about that, because they hadn't turned over their end of discovery yet. And you will note that whenever the judge put out an order for them to complete discovery, you'll notice that alibi defense and the particular deadline that was given to defense attorneys is at least a few months, because since it was April 17th, right? April, May, June, July, August, September. And the prosecution's got 5 more months than the defense had in that order to complete their discovery. So their full discovery deadline is for September of this year, whereas the defense's alibi discovery deadline was held for April 17th. And another freaking notable, sorry for droning on, is the fact that hypocrisy stands again with this. Because think about this, all the guilters, they have been raging about the fact that all of these supplemental requests for discoveries are so normal, right? That's so normal to them, and they swear by it. Okay, and now some supplemental some supplemental requests for discovery are normal, but the fact that there are now 5 motions to compel, I mean, motions to compel aren't typically needed that many times. 1, 2, and some heavy, we're asking for something unusual or whatever is kind of normal. But no, I mean, yeah, it does become a point where like, 5 motions to compel is kind of large. And we're coming up close to 20 supplemental requests for discovery. And each of those, why I said supports accidentally, is because there's always an appendix or a sealed exhibit that shows there is an exhibit, meaning, she's not just talking out of her butt or imagining things are there. She's asking for it while she's also showing in her exhibit why she believes an item exists, why she knows an item exists, or, that she has tried to work this out with prosecution and whatever the hell may be going on. Could all be things in this exhibit, but they've all been filed with exhibits. It's not like she's just pretending or dragging on the case. And defense alibi should sort of be handled in the same manner, not only because it is just another type of discovery, which a lot of people don't think about it like that logistically, but it is just another part of discovery, but it's like backwards or juxtaposed where defense is actually owing that discovery to prosecution. Versus the other way around. And typically, I think people mostly think about it as prosecutors need to hand everything over to defense. They don't think about defense attorneys also have to hand things over to the prosecution. And that's what I'm talking about. It's an Idaho thing that there is a particular deadline for that. And yes, we are far past that deadline, but a part of it has been on prosecution. A part of it has been because they have had to beg and compel prosecution to hand them over paperwork that literally is still in litigation. It's legitimately the next hearing we are waiting on is gonna hold 2 more motions to compel. I'm imagining they're probably going to have the hearings on the same day. If I had to guess, we're probably going to possibly have those on the same day. And those are going to pertain to some of that same information. So the hypocrisy comes in where they don't allow that same juxtaposition for Ann Taylor and her team to continue on with their, alibi arguments, why they don't expect that prosecution should have already turned over all of this discovery information 18 months after everything. I mean, they don't expect that of prosecution, but they expect that of defense attorneys, and that is speaking volumes. Not to mention the fact that the one hearing that they were actually going to have where they were going to speak and file about alibi deadlines was actually vacated by the court itself. And one of the issues at that vacated hearing was actually the notice of alibi. And the state prosecuting attorneys tried to remove the ability for him to be able to utilize an alibi due to it have gone by months and months ago, even though it wasn't Ann Taylor's fault in particular, because the court vacated the hearing, which gave her a little bit more time to actually file that alibi. But it's up to John Judge. He can totally extend as much time necessary to Ann so she could actually add to this alibi. He could see more notices of alibi if that's allowed. It can be extended. Extensions are completely up to the judge. And you would guess that, yeah, all of that should be allowed, especially since, prosecution's been given all the time in the world to come up with things that they've claimed to have had since the date of arrest. So, yeah, well, I'm not going to tell you, that I'm going to believe either one of the analysis as far as it pertains to cellular location interpretation, but I do kind of support defense in this. Not kind of, I fully support defense in this because, I guess sometimes you have to fight fire with fire, which doesn't seem that logical, but in a court where this junk science hasn't been thrown out, I mean, hell yeah, get your own expert to go up there and, show how it could have been exactly the direct opposite. Could be talking about complete junk, hair identification here. And still, I mean, if they're going to use it against me, I damn sure want my own expert telling you why that hair might not belong to me, right? So even though John Judge claimed like this was sort of an alibi or whatever he said, I think he called it so-called an alibi. As was mentioned by Ann Taylor here, counsel for Mr. Kohberger is aware that the case law broadens the definition of the alibi with the statutory requirement of a specific location to more broadly include the disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. At this time being key word here, corroboration of Bryan Kohberger not being at 1122 King may be brought out through cross-examination of the state's witnesses. At this time, Mr. Kohberger cannot be more specific about the possibility of witnesses and exactly what they will say. The defense has been hampered by the state's own choices. How the hell did I just say that? This defense has been... The defense has been hampered by the state's own choices. See, I totally English. The state chose a secret grand jury rather than the planned preliminary. Had the state moved forward with the preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. But they didn't have that opportunity. Instead, they were provided merely a transcript of what happened after they fought for said transcript to be compelled. And they go on to state, instead, the defense has only received on July 27, 2023, a copy of the testimony that the state chose to elicit. Review of such is underway. The defense had to obtain investigation materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. The state made draft disclosures just 2 weeks ago. The sufficiency of those disclosures is currently being analyzed. Now, this seems to be the state that they are still in or were in, last year whenever they had to compel the information from the FBI. They had to compel the prosecution to give that information over in the first place, okay? Big deal. And all they gave was a draft, and now we're going to have a motion for them to give the whole thing again. That's what one of the new motions to compel is going to pertain to. It says corroboration of Bryan Kohberger not being at 1122 King may be brought out through expert witness presentation. That analysis is underway. The defense has been diligently working to analyze relevant discovery materials and conduct its own investigation. Notably, the defense had to obtain an order to receive relevant discovery materials. The delay hampers the defense's investigation. So here they've been hampering it the whole time, but then, being like the little kids in the back seat asking, are we there yet?